Before I start, I'd like to acknowledge the presence of the Nairobi branch council members. This is the Law Society of Kenya Nairobi branch, as well as Mr. Shadrack Wamboi, who represents Dunstan Omari. So I will start by reading the statement that was issued by the Law Society of Kenya Nairobi branch yesterday, and then make a few remarks. The Law Society of Kenya Nairobi branch has received information regarding a notice issued by the Directorate of Criminal Investigation dated 21st of February 2023, served upon Advocate Dunstan Omari. It is our belief that the notice is meant to intimidate, threaten and prevent him from discharging his duties as an advocate and an officer of the court. Lawyers in Kenya have been intimidated in the recent past by external forces that attempt to limit the right to representation and expression. We are outraged and apprehensive about the environment in which Kenyan lawyers have to practice. The advocate's security is now in question, as the body which is meant to work with the lawyers in dispensation of justice is now exerting undue pressure to frustrate the existing client-advocate relationship between the said advocate and his client. The alleged offences, as highlighted in the notice, have been used as tactics to cause the advocate to execute his duty to the client in fear and trepidation. We strongly condemn the actions taken by the DCI in attempting to curtail the advocate's freedom of expression as provided under Article 19 of the Constitution of Kenya. As per Section 134 of the Evidence Act, the DCI should respect advocate-client privilege. It is becoming common practice that lawyers in Kenya have to look over their shoulders when discharging their duties. This has to come to an end. Our fears are heightened as we reminisce the recently concluded case of the late Advocate Willie Kimani and continue to mourn the untimely deaths of our advocates like the late Jared Ratemo, the late Stephen Mburu, and the late Anthony Ngunjiri, amongst others. In light of the above circumstances, the LSK Nairobi branch strongly condemns the said actions taken by the DCI. We further demand that the government, with all relevant authorities, including the DCI, National Police, Director of Public Prosecutions, and the Judiciary, take appropriate and immediate measures to protect advocates and channel efforts towards access to justice. Having said that, ladies and gentlemen, as advocates of the High Court, we are first officers of the court. It is our duty to discharge, to represent our clients faithfully, dutifully, and in the best way possible. We cannot do this if every single time we have to look over our shoulders because we are being intimidated, threatened, or harassed. And this is not an isolated incident. We have had cases in the past where we have been called to go and assist a colleague or two who, while carrying out duties attending to their clients at police stations, have been arrested, bundled up with their clients, and are in custody. We are saying the police, the DCI, and the lawyers are all working to serve the same society. So why is it that we are pulling at opposite ends? We should ideally be working together. We are in this together. It is for justice. It is to ensure that we are preserving the rule of law. And it is important that we pull together so that our society is actually receiving the best in terms of representation from the advocates and in terms of preserving the rule of law and justice. Having said that, ladies and gentlemen, thank you very much. I would now like to invite Mr. Shadrack Wamboi, who actually represents Mr. Dunstan Omari.
Notorious fact that on the 21st day of February 2023, Mr. Dunstan Omari, an advocate of the High Court of Kenya, a distinguished legal practitioner, was summoned by the DCI over what was termed to be offences that were committed on the 8th day of February 2023. You will recall that on the 8th day of February 2023, police officers had attempted, or rather, Dr. Fred Matiangi, the former CS Interior, was apprehensive of his arrest by the police officers over alleged offences that he was not aware of. Now, Mr. Omari, taking instructions from his client, made a press briefing indicating to the whole world over the apprehension that Mr. Fred Matiangi, Dr. Fred Matiangi, was feeling at that point in time. So subsequent to that, we saw this invitation. It's an illegal invitation, as we call it, where Mr. Dunstan Omari was called or invited to the DCI offices to record a statement over what he witnessed or over the instruction that he received from Dr. Fred Matiangi. Now, one of the basic principles, and this is something that we invite the DCI to also relook at, or rather seek guidance from legal officers attached to his office, is that there is a client-advocate confidentiality. And this is just synonymous to what we will have between a doctor and a patient, so that any information that comes to the knowledge of an advocate cannot be readily disclosed, and at least not without the consent of the client. So to that extent, we find that the DCI is confusing between the role of a lawyer and any allegation as far as a client is concerned. So that what we urge the DCI to be doing is to distinguish between roles of a lawyer and offenses that are committed by a client. Again, we find it to be very hostile to the oath of office that Mr. Dunstan Omari took as an advocate. So much so that while he is discharging his duties and functions as a lawyer, he is summoned. Yet, on the other hand, the very client who he was representing has not been summoned. The Right Honorable Raila odinga, who was there, who issued a press conference in tandem with what Mr. Dunstan Omari issued, has not been summoned. So the DCI must, moving forward, and this is what we urge of him, he must ensure that he treats all parties equally. And as a creature of law, an office that has been created by the Constitution and the relevant statutes, he is obligated to ensure that we promote or implement that law in the manner that it is. So that moving forward, of course, we approach the High Court, the Judicial Review Division, through the orders of Honorable Justice Jairus Nga. We have stopped the implementation of those illegal summons, so that we will not be attending those summons as it was initially intended. We had initially committed to attend those summons at noon, but we are not going to honor them. This is thanks to the Solomonic wisdom and to the courage of the Honorable Court to stop those illegal summons. We'll be returning to court on the 8th day of March 2023, where the court will give us further directions. But this should be a pointer to the Honorable DCI, that moving forward, let him try and compare notes with the office, the LSK office, be it the Nairobi branch or the national office, so that he can be well advised on how to deal with matters that touch on lawyers. I think that should be all from me. I can see my seniors present. My senior Nyaberi, Samuel is here, Sam Nyaberi is here, and other members of the Law Society of Kenya. Even my senior Cliff Ombeta is also around. If they have a word, they can also share with the members of the press. This is not an attack only on Mr. Dunstan Omari. This is an attack on all advocates, people who want to protect the dignity of the law. Thank you.
You take an oath. When you take an oath, you must stick by it. And what does it encompass? Also the Advocates Act. If the Advocates Act comes into play, then they will have something called privileged communication. If privileged communication is there, then there is nothing else that an advocate can do. You only stick by what your client has told you and nothing beyond that. So Mr. Omari has been called. By who? The DCI. For what? He does not know, because if you look at that summon, it has nothing clarified. Is there an accuser? He should be told about that well in advance, so that he knows why he's being summoned and for what purpose. If it is because of his calling as an advocate, then that oath and the Advocates Act has already protected him from the word go. So what does the DCI want? For him to come and say what his client told him? That one, you know, it cannot happen today or at any other time. The client also knows that whatever he has told his advocate is also privileged. So what do you do first? If you think an offense has been committed, get it done Write it down, get an OB, get a statement from the person who's complaining, inform the lawyer so that we know. These are not those days that you call somebody, bundle him and tell him, maneno utatuambia mbele. Those days are over. We know it. Even during campaigns, we say that these issues of police harassment must stop. If you are going to harass a lawyer for doing his duty, then where do you stop? Do you have a limit? If this is what is happening at this particular moment, then it shows that there is no limit. And we are going back to the days that we are saying should have been long gone. An advocate is an advocate. I remember when I was doing the Willie Kimani case, so many other lawyers disappeared from me, but I stood by my oath until the case was over. Why? Because he trusted me, he relied on me, it was his right, and I had to safeguard them. Isn't this the same case for Mr. Dunstan Omari? Are you going to call him and tell him that? And you see, if you look at that summon, it has got that part that gives the penal part of it. That if you do not attend, it's an offense. The question is, which offense? I will not add anything else. Whoever might have been there on that particular day or not. He acted on instructions. He was told by his client what had happened. That is where it ends. You cannot compel him to come to you and tell you anything else beyond there. Regardless of who you are, whichever office, you cannot do so.
Now is a drawback on the progress that we have very